Hello. The next case I want to talk to you about is a early 19th century authority, and it's a case called Morice and Bishop of Durham, which is 1805, 10 Vasey Junior, page 522. Or for those of you who are fans of the English reports, you can go to volume 32 and it's at page 947 that you will find the report. Why is this case interesting, Morice and Bishop of Durham? Well, firstly, the protagonists in the case are interesting, or some of the actors in the case, in the sense of, firstly, the advocate who was involved, or one of the advocates, that's Sir Samuel Romilly. There's a picture of him there. Incredible individual in the sense of law reform movements in the early 19th century, involved in the abolition of the slave trade movements, capital crime abolition of the death penalty, as well as bankruptcy law reform, of course, and equity. So he was a practitioner in the equity courts, largely until his untimely death, which I'll address in a moment, before the Lord Eldon, who's here, and there's his signature for you to have a look at. So two of the interesting characters involved in the case. Romilly did have an untimely end. He was so heartbroken in 1821 by the death of his wife that he slit his own throat, killed himself in just right next door to the Institute of Advanced Legal Studies in London. Obviously that wasn't constituted at the time, but in the building is a blue plaque that you can see there, commemorating the life of Sir Samuel Romilly. So why were Romilly and Eldon thinking about trusts in the context of Morice and Bishop of Durham in 1805? Well, if we take some of the judgment of the the Master of the Rolls at the time, that's to say Sir William Grant, we can understand why this case is interesting. So why Morice and Bishop of Durham in the context of the three certainties is a noteworthy case. And it's noteworthy because, as Sir William Grant said, there can be no trust over the exercise of which this court cannot assume control. There must be somebody in whose favour the court can decree performance. So there must be somebody in whose favour the court can decree performance. Well, for us this case therefore is interesting because it talks about two things. Firstly, enforcement, or court involvement in enforcement, as opposed to a beneficiary perhaps seeking to have their equitable rights respected by a trustee, so going to litigation to get an enforcement. That's the first point of note. And the second is the idea of the object, or seti K as we've called it in some other video casts, or beneficiary, so object, beneficiary, seti K, synonyms for the same idea, the recipient of the bounty of this trust instrument that we're thinking about. And it's important in the context of Morice and Bishop of Durham because the objects of this purported trust were, in essence, certainly the last of the four objects was a purpose trust. And as we know, generally, apart from some anomalies that we'll perhaps address in a different podcast, videocast, those ideas of purpose trusts are anomalous, say for cases like Reed Dean or Pettingill, those cases that are addressed in Re Asta, for example, as anomalies, mean that when we're thinking about objects, we normally think of a human as the beneficiary, because of course a human can enforce. Horses, like in Reed Dean, do find it problematic to bring cases in the Chancery Division, unless there are residuary legatees. So here the fourth aim was this, which is the most difficult: the advancement of objects of general public utility. So we might argue that that's a purpose. And that's why Morice and Bishop of Durham, when the Lord Eldon on appeal held that that was too vague and uncertain in terms of objects, so the trust was ineffectual, that we have what's known as the rule emanating from Morice and Bishop of Durham, that for a trust to be enforceable there must be someone in whose favour the trust can be enforced, save for those anomalous cases I've mentioned. And the very recent critique by Getzler in Landmark Cases in Equity, a collection of essays that you must all engage with. It's an excellent collection. You'll see that he casts doubt on whether or not that idea that a trust must have an individual for it to be enforceable, or in whose favour that trust can be enforceable, is perhaps not what Morice and Bishop of Durham is saying. And I'll come back to his arguments in another video. But for now, then, we'll summarise by saying that Morice and Bishop of Durham is useful for us in this three certainties context, because it outlines the idea within the three certainties that one of those certainties must be the certainty of object, the idea that there must be a human who can enforce the trust instrument. And on that point, myself, Lord Eldon, Sir Samuel Romilly, and that's also Basil Montague, up there, will bid you goodbye until the next video. Goodbye.